Good afternoon, Wisconsin. Congratulations on reaching the national finals, and congratulations to you, to your families, your teacher, coach, all of you. Quite an accomplishment. And I am Ed Murphy. I'm a Superior Court judge in Tacoma, Washington, and I really look forward to hearing your presentation.
And I am Edward Volpe. I'm an attorney from Denver, Colorado. I've been involved with this program for many, many years, and I thoroughly enjoy hearing students learning these very important concepts. I look forward to your comments today.
Hi students, I'm Caitlin Johnston. I am an attorney in New York City and an alum of the We the People program. I did it in Indiana when I was in high school. So best of luck. You've already bested me because I did not make it to nationals. So I'm very much looking forward to your presentation, and I'm not standing to make you nervous. It's just a little bit more comfortable for a hip injury. So please excuse it, but very much looking forward to your presentation.
I would ask the students to introduce yourselves and then also your teacher or coach.
Hello, judges. Nice to meet you all today. We're the Unit 5 representatives from Wauwatosa East High School representing the Wisconsin Wildcard team. We are coached by Mr. Taylor McDaniel, and our names are Audrey George, Izzy Marjorie, Sophia Hefner, and John Cock.
You're on mute.
I am. That's the Zoom statement of the year. I'm going to read the question to you, which is question number 2 for Unit 5. In a letter to James Madison, Thomas Jefferson wrote, "A Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse or rest on inference." Do you agree or disagree with Thomas Jefferson? What are the advantages and disadvantages of a national Bill of Rights as compared to state bills of rights? What are the differences between positive and negative rights, and which are more important to the preservation of liberty? You may begin.
In 1875, the Ku Klux Klan deprived freed enslaved people of basic rights, such as freedom of assembly and the right to bear arms, due to the negative phrasing of the First and Second Amendments. The courts ruled that the federal government could not file charges against citizens in federal court regarding violations of other citizens' constitutional rights, leaving it up to the states to protect against these violations. This case, United States v. Cruikshank, is a clear example of how the negative phrasing within the Federal Bill of Rights does not adequately protect citizens' liberties.
During the Constitutional Convention, members of the Federalist Party believed that the Constitution in its original form was sufficient to protect one's rights. They believed that an explicit enumeration of liberties would prompt the exclusion of unstated liberties. On the contrary, Thomas Jefferson and the Anti-Federalists advocated for a Bill of Rights to maintain and shield the liberties of citizens. Compromise was needed to secure the Union, so a federal Bill of Rights was written with negative phrasing to enumerate protections against federal encroachment.
As noted by the Commission on the Bicentennial of the United States Constitution, quote, "America has always been about rights. While many nations are based on a shared language or ethnic heritage, Americans have made rights the foundation of their national identity," end quote. We recognize the importance of establishing rights through documentation, but the negative phrasing of our federal protections continues to fail Americans. In their implementation, federal judges are tasked with interpreting what rights the framers meant to protect through each amendment, a difficult task due to the broad natures of these rights. Naturally, interpretations have varied wildly, causing many infringements of rights since the formation of the Union. A few detrimental cases being the Alien and Sedition Acts, Japanese internment camps through the case Korematsu v. United States, and the overwhelming injustice that has led to so many civil rights movements. For example, the current Black Lives Matter movement has continued the fight to reveal and correct the inadequacies of the Bill of Rights. Human rights should not be dependent on other people's interpretation of an ill-defined negative right.
Positive rights are more important than the preservation of liberty. They are explicit and do not leave the interpretation of rights up to a singular branch of government that has infringed upon citizens' rights time and time again. The negatively phrased 15th Amendment was ineffective because of the significant loopholes that it created due to its vagueness. To remove these loopholes, the federal government passed the Voting Rights Act of 1965 and the 24th Amendment. These loopholes would have never existed if the 15th Amendment were initially written using positive phrasing.
While at times positive rights may inhibit the rights of other people, we must apply utilitarianism when evaluating the impact of positive rights. As long as there is a net gain in happiness, positive rights will benefit society more, despite the fact that others' rights may be more limited.
The positive guarantees within state declarations of rights have the ability to protect unique and important rights that the federal government does not. An example of this can be seen within the Wisconsin Bill of Rights, which ensures the right to fish, hunt, trap, and take game. This right reflects the unique values of our state. Citizens' needs can differ drastically based on location. Therefore, state constitutions are vital in ensuring the protection of specific citizen needs. State constitutions have the ability to be amended in a much easier process than a national constitution, allowing them to grant more rights to citizens. For example, the Equal Rights Amendment wasn't passed on the national level because of the difficult and slow process, but many state constitutions implemented it, ensuring equality among genders in those states.
While the negative phrasing of the National Bill of Rights hinders its overall effectiveness, the uniform and supreme nature of it is still imperative to the basis of a just society. Given the heterogeneous makeup of the United States, a document is necessary to protect American citizens' basic rights. The United States is currently progressing through a necessary period of social and political change. To further establish a free and just society, positively phrased amendments are necessary to protect the rights of marginalized citizens. This concludes our statement, and we are now ready for your questions.
All right, thank you. It's time to put away any notes you might have in front of you. What limits, if any, should be placed on individual rights listed in the Bill of Rights, such as freedom of speech?
Limits should be placed on freedom of speech in cases such as Schenck v. United States, when it interfered with the U.S.'s ongoing war involvement in the First World War, and this is which broke the law of the Espionage Act and the Sedition Act, passed around the same time. When citizen speech affects the well-being of the entire nation, such as going against the war which was protecting the nation, then it should be restricted.
I think additionally, speech and other rights should be restricted if the material is inappropriate, such as seen in the case Miller v. California, where obscene material was mailed to families in California.
Additionally, speech should be limited in places such as schools when the main goal is to educate our members of society and raise them to be beneficial members of society, in cases such as Bethel v. Frazier.
You have referenced the positive rights as rights that must be accorded to the citizens by their government. How high would you rate the duty of the government to provide security with regard to internal problems and with regard to any threat from a foreign country?
Could you rephrase the question, please?
Yes, I'm talking about whether or not the government must provide security to its citizens, both from internal problems and from external problems. Is that a highly rated positive right in your opinion?
I think that the government should be able to protect the country from security threats. As we saw after the aftermath of 9/11, the country passed the Patriot Act, which allowed government agencies to heighten security and internet surveillance. And although this did infringe upon people's right to privacy, I do believe that it was necessary in order to protect the country. Another example of another country would be Germany, which has 146 articles in its constitution. Most are positively phrased. And one of their articles is about protecting people against anti-Semitism, which I think is incredibly important given the history of that country.
To disagree with my colleague, these safety protections oftentimes end up taking away the safety of other Americans. One example of this is the court case Korematsu v. United States, when Japanese American citizens were sent to internment camps, and the government was claiming that it was attempting to protect the security of Americans, but it instead just threatened the safety of these Japanese Americans.
With the COVID-19 pandemic going on, in the case Jacobson v. Massachusetts, it was the court ruled that the government does have broad general say over the common health. So they were required to, or so mandatory vaccinations were constitutional. And that would protect the safety of most Americans. And that is one example of how we could provide more safety.
What circumstances might cause someone to lose rights that they have under the Bill of Rights or elsewhere in the Constitution?
Currently, only 2 states make felony disenfranchisement illegal. So in 48 states, felony disenfranchisement is illegal under the case Richardson v. Ramirez, and it is only illegal, the Supreme Court ruled in Hunter v. Underwood, when the felony disenfranchisement of someone is racially motivated. But you can see that according to the Sentencing Project, African Americans are 3.7 times more likely to be disenfranchised in the United States due to discrepancies in our criminal justice system. So in my opinion, I feel like felony disenfranchisement should not still be okay in 48 states.
In addition, to build off of my colleague's statements, citizens' rights are often taken away when they break the social contract or break the law. And this goes back to Thomas Hobbes, who built off the theory of the social contract. So when citizens break laws, they're breaking an agreement we all made to follow them, and therefore their rights are being taken. Their rights, the state has the right to take their rights away.
What is the difference, if any, between rights that are added through the amendment process and those that are established by a court decision?
Unfortunately, court decisions are oftentimes subject to bias, extreme bias, that occurs among the courts. Therefore, we should turn to bias training. An example of bias training being used within the courts is in the state of California. In 2020, they mandated that all judicial employees would be required to undergo bias training. And this leads to less misinterpretation. As opposed to the amendment process, which is more thorough, it leads to less misinterpretation of rights.
Court cases can also be overturned, while amendments are generally kept until Congress chooses to remove them, such as the 18th Amendment. But court cases like Serrano v. Priest initially established that education had to be equal among economic lines, which initially established the right to a free and fair education. But this was later overturned in the case San Antonio v. Rodriguez, in which the court ruled that the Equal Protections Clause of the 14th Amendment did not protect among economic lines for education. So court decisions can be overturned much easier compared to amendments.
May states allow citizens to perform acts and otherwise behave in a manner that would constitute a federal crime?
You glitched out for me. I don't know if anyone else, but could you restate it? Sorry.
Yes, may states allow citizen behavior that would otherwise constitute a federal crime?
Through the selective incorporation of the 14th Amendment, the 4th, 6th, 1st, 2nd, and 8th Amendments are all fully incorporated, and then the 5th is partially incorporated to the states. So under those amendments, crimes done under those amendments in the states, people could get in trouble for that, yes.
An example of states allowing crimes that are illegal on the federal level is things such as marijuana. In several states, especially since the last election, several states have legalized marijuana while it's still under Schedule 1 under the Drug Enforcement Administration. So there is often conflict, or not necessarily conflict, but differences between state legality and federal legality.
All right. Well, thank you very much, relax. You finished it. Well done. I really appreciated the presentation that you had, the participation by everybody. You packed a lot into the time period that you had, cited lots of different cases. And this is really a broad question. There's a lot that's in there and a lot of different directions that you can go. And it's really, I think, an opportunity for you to show not only your knowledge of specific cases and specific areas, but also your personal thoughts and opinions. And we got some of that through the presentation about what you thought about different subject matters. So I really did appreciate that. I thought it was a strong presentation. Korematsu is a very important case in our country's history in trying to look at some of the wrongs that have been done. I enjoyed hearing that case being mentioned, talking about Germany and their constitution. You just pulled a lot of different cases in, so very well done. And I thank you for that.
I agree with those comments. I thought you were very well informed, and you did come up with specific citations that were very important. With regard to my question on security, you did make the point that it may take away rights from some of citizens who would otherwise be entitled to those rights. The reference to Korematsu was excellent in that regard. I would urge you, in your thinking about that question, to talk about the military draft. We may be able to force individuals to come and provide military service if our country is threatened. And certainly security was greatly on the minds of our founders, because 7 of the 18 powers conferred upon the federal government in Article 1, Section 8 had to do with raising an army, a navy, controlling the militia, so forth and so on. So that was a right, a positive right that was well concentrated at the time of the founders drafting the Constitution and the Bill of Rights. Another example, of course, that you came up with was the Patriot Act, and I thought that was excellent in terms of allowing the government to do some things that perhaps could not have done before. The reference to the German Constitution I thought was excellent. You talked about the ease of changing state constitutions and their Bill of Rights. Certainly, states have been more liberal and certainly more broadly stated with regard to their bills of rights. Colorado's Bill of Rights has 34 separate provisions. And certainly the fact that the citizens of a local area, as in an individual state, can concentrate on issues that are important to them, I think is a very important aspect of the fact that we don't have to have nationwide agreement with regard to the rights that are important to the people of a specific locality. The reference to the development of rights, you're talking about the 15th Amendment not being particularly effective until subsequent amendments, and the incorporation of the Bill of Rights through the 14th Amendment with regard to all persons, not citizens, but all persons. The Richardson case, the Hunter case, I thought those were excellent references. The whole idea of whether or not we are according criminal justice to all aspects of our society, I thought was an excellent point too. And you talked about the philosophy of Thomas Hobbes and the social contract. Certainly that is the way government began. I sometimes tell the story that Caveman Org said to Caveman Org, how about if we agree that neither one of us will bash the other over our head with a club and take everything that person has? And so the social contract began with regard to cavemen saying we'll protect each other from ourselves. And that was an important point in the development of positive rights and negative rights. Again, the reference to marijuana was the difference between federal and state jurisdiction, I thought was excellent. But that's enough from me right now. I thought you did a very good job. Thank you for your hard work. Take this knowledge forward and become active in your society with regard to what you can teach your fellow citizens?
And I'll pick up right there. It's very clear that you as a panel and as individuals are very well informed on both the historical context of what we're talking about today, as well as how that comes forward into our daily life. Audrey, you jumped on my question and told me we were going to talk about felony disenfranchisement, and I will tell you that wasn't the right answer in the sense that there are plenty of answers, but that was the answer I was thinking about when I asked the question, because I think it's so pertinent to today's conversation. Is do we feel like that's a fair punishment for someone who already served time? It's a really interesting issue. So I was delighted when you came out with it. And John, you did a good job returning to first principles on my question and saying, well, it's about the social contract, as Judge Volpe said. So really, really great teamwork in showing us that you had good command on the material, but also you were able to bring in current day examples. This question is actually, we're a couple rounds in, and it's a really fun one as a judge because students are taking it a bunch of different ways, but I'm recognizing it's quite hard to prepare for because you have no idea where we're gonna throw you follow-up questions from. And we kind of went all over the map, and you guys hung with it beautifully, covering a bunch of different topics. So great, great, great job.
Okay, well, I think that concludes this presentation. So I want to offer you all a round of applause for a job very well done.
Thank you so
I'm
much.
going to
Thank you.
Thank you.
I'm going to stop the recording.